The local information is in a movie control in a minute. So this is under Procedural. Before I take you on the to the FIR, the background in which the FIR has come to be registered, so that is very important in the facts of the present case. So this is a classic case in my respect to submission. It's abuse of the invocation of the Procedural Act. So before I get to that, the applicant, so the first case, the Honorable Court would have of Mahesh Bhagwan, item number 3. So he is a president of Kodina Taluka Congress Committee as NXT appointment. He is an RTI activist and an environmentalist who has now joined in 2023 a political party. Sir, he has given a crusade against one ex-member of parliament whose name is Neenu Boga Solanki. Because of the political rivalry, the present FIR has come to be registered. Sir, in what context? What is the stature of that person and how this FIR is registered? Allow me a few minutes so that I can enter on that. So, if we look at that angle, we would see why this invocation of the present FIR. But this Mr. Solanki, who is a political rivalry, he was convicted of a 302 case in 2019. He was acquitted by the High Court in 2024 May. All the FIRs, the history of which are stated before the Honorable Court of all the accused before the Honorable Court are prior to 2019, when he was not convicted, and after 2024, after he was acquitted. So this is one of the things which may weigh before the Honorable Court to show the credibility, stature, and the dominance over the state machinery. Allow me to take this Honorable Court to the observation by the Honorable High Court in his matter, wherein sir, High Court એવું કહે છે કે હું ગુજરાતનો જજ છું, હું ગુજરાતનો જજ છું કે ક્યાંનો જજ છું કે હું આ વિડીયોઝ અને આવા સર્કમસ્ટન્સીસ જોઈ રહ્યો છું ગુજરાતમાં. That the Honorable Court would find at page 103. The background of that case was the wife of one of the accused was alone with the kids at the house. Where this Neenu Boga Solanki, along with 3 police inspectors, his staff, along with his henchmen, ransacked the entire property and damaged and destroyed with swords, iron sticks, etc. in the broad daylight. And the version of the FIR of the applicant was not recorded. In that background, what is the finding of the High Court and what was the conclusion of the High Court that the Honorable Court would find at page 103? So page 104 are the prayers that you register a fresh FIR, you take action against those 3 police inspectors who had come along with Mr. Solanki. So that is at 104. Sir, broadly, I'm just making a lot to I'll just read 2-3 paragraphs, sir. as to what is the dominance of Mr. Solanki. Page 115. 115. Paragraph 17. 17. Bottom. In the course of hearing, Mr. Yagnik made available a laptop of which the compact disc containing the video recording of the entire incident was played. After watching the CD, I wondered for some time whether I was a judge in the state of Gujarat or in any other state. The videos speak for itself. The state submitted that they do not question the genuineness of the photographs which are on record, including the 3 CDs. I also take notice of what has been stated in regard of affidavit in reply by the police officer referred to the above. It is so apparent that Mr. Solanki led the unruly mob which created a havoc on the fateful day at a residential house of the writ applicant, and in all the photographs which are on record, Mr. Solanki figures with accomplices armed with swords, hand pipes, baseball bats, as on the date. Mr. Solanki is a free man and all his accomplices are also roaming around freely. Keeping that in mind, please come at page 118 at paragraph 22. In continuation of that, what is observed by the Honorable Court after taking paragraph 22, the lack of anxiety of the police and its inertia in acting on the complaints lodged by the writ applicant promptly and effectively is apparent. The police have been a mute spectator so far. The entire state machinery appears to be stacked in favor of Mr. Solanki, probably because he belongs to the ruling dispensation. The reluctance of the police to perform their duty in the present case has caused the writ applicant to approach this court in its writ jurisdiction. Now, sir, 23 Chillati Chauthi line, sir. It should not have taken more than a day for a police to arrest the person who were the members of unlawful assembly, more particularly when 3 CVs were produced by the writ applicant. 3 months have passed by now. What message the state has conveyed to the common people at large after this episode? The message which reached the common people is that persons like Solanki can get away with the help of police even after committing an offense. So this is, even today, this finding has the relevance. Even as on today, Mr. Solanki holds that dominance over the state. After that, what the Honorable High Court ultimately did, my own FIR, I was a applicant before the High Court. My own FIR was quashed by the High Court, recording that the version that I stated in defense of, because of the influence of Mr. Solanki, the PI did not record what I wanted to be recorded, and that is why the Honorable Court, paragraph 35, page 126 bottom, FIR so and so, lost before so and so, is hereby quashed. And please see D. The DGP CID shall ensure that no untoward incident occurs on account of the incident and no threats are administered to any family member of the victim residing locality. So this is the background on which Mr. Solanki acts. Immediately after that incident, I, Mr. Makwana, was brutally beaten and 11 fractures occurred by the henchmen of Mr. Solanki. So that is also recorded. I take a notice to that. By the accomplices, I moved the Honorable High Court. High Court, by issuing the notice, came to the conclusion that yes, something has happened and this gentleman requires the police protection. And hence, the High Court directed the state to provide me the police protection on 28/12/2016, page 94. Page 94 subparagraph. By the next returnable date, an appropriate reply shall be filed in regard to the subject matter of this petition. The state shall see to it that appropriate police protection is provided to Mahesh Makwana and his family members. A strong apprehension has been expressed on their behalf and their lives are in danger. The next page. I will not read through this order, but by disposing this, taking into consideration what I read to the Honorable Court prior to the in point of time, taking into consideration that order, even this FIR was transferred to state CID, right? Without just observing that I know Mr. Solanki matters have been appearing before me and I know the credence and hence in the fitness of case, let me transfer this FIR. Since 2016 till today, the police protection to me continues around the clock. And in that circumstances, Mr. Solanki has been successful in registering other FIRs against me after he was acquitted by the High Court, by the Honorable Court. And it is alleged that though the police protection is provided by the very Koreaner police station, who has registered the FIR in which we have impugned before this Honorable Court. That very police station, police officers comes to my protection. And the next allegation is that I am involved in an organized crime. Sir, how it is possible? If round the clock security is with me, I am participating into it. What sort of allegations are raised against me? So that creates serious doubts in the mind of a reasonable man. Sir, I have contested legislative assembly election recently, and I have secured more than 50,000 votes. And this 50,000 votes stands a testimony that I have deep roots in the society. So that I will take in the later part, that how do I have a deep root. So the present FIR is only to demolish my political career and to make sure that I remain behind bars so that I could not participate in any election procedure. On the contrary, that I have with me the details of at least 50 FIR registered against Mr. Solanki. So this FIR, please note that these FIRs could see the light of the day.
What are the FIRs that are registered against you?
Please, sir. That is mentioned in the FIR. That is the second thing which now I will take the Honorable Court to. But because of such FIRs being repeatedly filed, that is why the people fear to stand against him. And whosoever stand against him, this is the result of who gets it. So now, please see. Sir, before I take the Honorable Court to the FIR, this is a background in which this FIR is filed. Sir, a broad legal submission in how we would see the present FIR, the ingredients of the provisions which are invoked in the FIR, and thereafter, sir, allow me to take the Honorable Court to the FIR. If the Honorable Court so permits, sir. Please. So 3 sections are invoked against me. 3 sections are invoked against me. 312, 32, and 34. So please bear in mind that, sir, apart from this, 90 days are over. Subsequently, the Honorable Court has granted 45 more days, which ends in February. In these 3, what is punishable under Gutsito is the organized crime. It is not the continuing unlawful activity. That is succinctly explained by the Supreme Court in a case which I'll take to the Honorable Court later, after I complete the merits. So, to invoke the organized crime, what are the 4 or 5 ingredients which are required, which are mandated, and which requires a strict interpretation while invoking Gutsito? The first is the continuing unlawful activity. That is a part, not to be read in isolation, but to be read collectively. Second is that this continuing unlawful activity has to have an object of gaining some monetary benefit, some pecuniary benefit, or any other advantage. Third, this continuing legal activity, which I have entered in, I don't deny that, I have entered in. That activities has to be similar activities in the past. To take an example, that I'm a chain snatcher. So continually, I'm a bootlegger. So continually, it has to be shown that I have been doing this process, similar activity, because this act is to curb that. Fourth is, I have to be a member of a syndicate. And I have to operate it singly or jointly as a member of a syndicate, or on behalf of that syndicate. Then, sir, this four things, if collectively is there, then it is an organized crime. Even one or two are missing, it is not an organized crime. It could be an activity in the penal statute, BNS, IPC. So there is also a non-application of mine while granting sanction to the registering the FIR. That I'll take later. Sir. Since the charge sheet is not filed, I'm not privy to what weight before the authority. So now I take the honorable court to the FIR. So there are 5 appeals in the FIR.
This is the FIR.
Yes. FIR at page 18. If the honorable court see page 19, there are 5 appeals. Sir, except number 2, all are before the honorable court because all are arrested. Number 1 is the honorable court is holding the brief. Number 3 to 5 is the next matter. Let me take, sir, all annexures, everything is same. So allow me to take number 5 first. Muna. Sir, if we see these antecedents, it is at page 25. Please come at page 25. The page 25 on the top, Postak key, Muna, Kote, so on so. So there are 3 FIRs. Number 1, that is happened in 2014, an FIR was registered on the ground that the religious sentiments were hurt. That briefly is explained at page 31, but however, I don't bother the honorable court to read the entire paragraph. The brief allegation against him was that there was religious sentiment of a particular community hurt by circulating some message. And one thing led to another, and an FIR came to be registered. More than 20-30 people were there in the FIR. The only person out of the 4 applicants before the honorable court, only 1 person was there in that FIR. Rest 3 are not there. Rest 4 are not there. In that, the honorable court in 2017 has acquitted you. State has not filed an appeal. So thereafter, number 2 and number 3 are the FIRs of the same date. And why this FIR came to be registered, I will even justify that. How it is false. Number 2 is, both this FIR are registered on the very same date, 13/7/2024. After Mr. Solanki was acquitted. On that date, 2 things are alleged against me. There are 2 FIRs I've annexed those FIRs in the first FIR is that Lari Gallanu Daban Dur Karwa Mate Archan Kari collectively by the very 5 accused which are accused in the FIR. Those 5 people have obstructed in removal of encroachment and hence an FIR came to be registered. That is number 2. All are bailable offences, so we were granted bail. Number 3. The history is that Paryadina Patina Keva, Pitana Kevanti, demolition through. And that is why such a Dukan Jane, Garo Api, Maramari Kari, chain snatching Kari, threatened Kari, and Nikri. This is the third FIR. In which the Honorable High Court has granted me bail. All are on bail in that area. Now taking these 2 FIRs a Gutsi is invoked against Muna. How is it justified to invoke Gutsi, taking into consideration that offense has been registered on the very same date, two different offenses are registered, and see the audacity of the complainant to register an FIR even against Muna. I can understand others have 10 antecedents, 15 antecedents. But what way with the competent authority to grant a sanction, to prosecute him? In first FIR, there is acquittal, and the second FIR, after charge sheet is filed, immediately this FIR is registered and he is sought to be arraigned as an accused. The object of Gutsi talk is different. However, I'm a part of a syndicate. So the second accused, that is Ramesh. Now let me see if the Honorable Court to that. Ramesh, the Honorable Court would find a page preceding page 24. The first FIR against Ramesh, first and second FIR, I have been acquitted. In 2014, an FIR was registered and I am acquitted. Number 3, the investigation itself is stayed by the Honorable Court, High Court. That order they themselves have put on record. And fourth and fifth is the same FIR. કે અડચણ કરી ડેમોલિશન ડ્રાઈવમાં અને ચેઇન સ્નેચિંગ એન્ડ મારામારી ને દુકાન જઈને. The fourth and fifth FIR, everybody are common. And that is what led the invocation of the Gutsi against everybody. Now, if we see that past more than one charge sheet is filed, what pecuniary benefit? How is it a syndicate? And how is it a similar offense? Now, please take of Harish, that is number 3. Harish, Ikubai, Siddhi Damania, that is 23. Sir, before the Honorable Court takes up, very well, let it show through. No difficulty. First, sir, 1, 2, and 3 FIR number. Every place the accused number 3 is alone. He is not part of those people who are before the Honorable Court. So as to allege that he runs a syndicate or on behalf of the syndicate, etc. There are no allegations that other 4 people are involved. And the trial is still pending. None of the people before the Honorable Court are acquitted in any manner. So the presumption continues. In the 4th FIR, there are cross FIRs. In the 5th FIR, again, alone accused number 3 is involved. Now, please see the variety of the offense in the very same accused. The first FIR and 5th FIR is regarding to offenses under the Mines and Minerals Act. ખનીજની ચોરી કરી. અને બીજી જગ્યાએ ક્યાંક ગાળાગાળી થઈ છે, ત્રીજી જગ્યાએ ક્યાંક મારામારી થઈ છે. Where is the similarity in the entire, if we see the history of all these accused people? There are different judgments which I take the Honorable Court to, which says that chain snatching છે, highway પર loot છે, fracture gang છે, તો આમાં involved છે. But there has to be a similarity of the offense in the past through which you can look back. So thereafter, again, the common FIR, last two in the Honorable Court sees. Common FIR. Now kindly come to my Makwana, that is number 1. So number 2 is not before the honorable court. So I'm not reading that. Number 1 is Mr. Makwana at page 20. The investigating officer himself also has filed a chart, which I'll take your lordships after this. So number 1 and 2 are the FIRs in which the applicant is acquitted. How can you draw presumption when he is acquitted? Supreme Court says no. If you're acquitted, this cannot be taken into consideration while invoking Utsito.
1 and 2.
1 and 2. Number 3 is acquitted. Number 3, trial is pending. However, he is the only person registered in named as an accused in the FIR. He gave some. I propose to read number 3 and number 5, how unique those cases have been registered afterwards. Number 4, the investigation itself is stayed by the High Court, which is noted. The Honorable High Court is also aware that this is the man who has been behind this in registering the political witch hunting. Number 5, again, I'll take number 5 in the last one. Number 6 is that no coercive step is granted by the Honorable High Court. So no charge sheet is filed. One or more charge sheet is filed. It is not that case that one or more FIR is registered that you have to look back. Charge sheet is not filed. Only the FIR is filed. So thereafter, accused number 1, even that in accused number 1 is there. So if we see number 1, 2, 3, 7, number 6, 7, and 8, accused is the sole person against whom an FIR is registered. And see the variety of the offences. Nowhere it is said that a similar transaction is there in the past. I'm troubling the Honorable Court only for the reason that this is how the machinery is misused. And last two.
Problem is not that. Problem is that both are that one. The complainant and the accused.
Sir, if that would be so, then how much I am involved, he would also have been prosecuted.
Should be.
It should
but
be.
It is not right now. Right now you are there before.
Right now I am there.
But has it been? It is not the case that you are just clean enough.
No, sir. That is not, sir. That is why I say that I have antecedent. But that antecedent is enough to justify the invocation of Utsito. That is the case.
So that people can live at peace.
Understood.
You people are fighting, people are under unpeace.
Understood, sir. But
so one day it will come that the other side also will be taken.
So that day one has not come yet. Only in one case he has been convicted. In all the other FIRs, if the Honorable Court would call for the record, the Honorable High Court has recorded such thing. Against me, there is no such finding.
But then you cannot justify that.
So I am only showing the background in which the FIR
I understand. See, there are things going up. Public peace has been,
disturbed, sir.
disturbed. So it is not I'm saying that he is good, you are good, he is bad, you are bad. I'm not saying that. But ultimately what? Why is the act for? Act is for what?
To curb the organized crime.
Exactly. Or for what?
To maintain the law and order. Yes, sir. To maintain peace.
Now, that is what we are into. What the court is anxiety is that yes, you may be somebody else is that nobody else could have done it. It is only the two what we call it.
It's a rivalry.
Strong heads who could have brought each other at peace. Police is not doing anything. That the Honorable High Court has mentioned that.
Please, sir. That is what I wanted
So
to
now
make.
see, it's either of you. Either of you can bring peace
Whosoever
together.
stands against him, there will be
You are standing.
consequence.
You are also standing. He is also standing now. You only both can bring peace at the peace to against us.
Then he both us stand fast. Then there could be
Yes, so that,
on a lighter note.
now,
No,
that also will come up. The investigating officers will do that against him also. There are being offences registered against him from the against the complainant. One day will come when somebody will question.
He is not the complainant, but at his behest, everything happens.
Doesn't matter. But someday it will come that there will be complaints against him also. So everybody has a fate. Baap no gado bada se, he also will go insane. But right now you are not that.
Understood, sir.
You are not that so clean.
I'm not saying so.
Cannot.
I'm not saying so. I have antecedents. But in what background do I have antecedents? One,
Yeah.
two, in what legality the provisions are invoked? How much ingredients are satisfied in order to justify an invocation? I'm on that. The last two offenses are common. The investigating officer has prepared a chart and filed an affidavit. Investigating officer,
You are
page 15, 1-5.
Affidavit.
In Mahesh Pratap. In both they have filed for common chart is there. I am affidavit. Internal, sir, affidavit to internal. So there, whatever I have read before the honorable court is mentioned. કોણે કેટલા ગુના કર્યા છે અને કેટલા common accused. Apart from the fact that no similarity of offense, etc. How much more than one accused are there in order to justify, syndicate, operating, illegal activity, etc. This the honorable court may take a note. So thereafter, I rely on few judgments.
Yeah.
The legal submission which I have broadly made to the honorable court as to the ingredients of the organized crime, as to what is punishable in organized crime and not a continuing illegal activity. That this is a landmark case number 1, that is Maharashtra versus Shiva. So there only 2 paragraphs.
Regarding acquittal.
Yes, here there was an acquittal. Why there was an mapoka invoked against them? They said there is an acquittal. Why do you take into consideration? The fact and the ratio that is laid down in this particularly is 2 things. One, that mere registration, filing of charge sheet and taking of the cognizance. So that is why I request the honorable court to have paragraph 10 and 11 of the very judgment. Internal page 5, paragraph 10. It's a very short judgment, 2 paragraphs. The very fact that more than one charge sheet has been filed against respondent alleging offence punishable 3 years is not enough. As rightly pointed out by High Court, commission of offence prior to the enactment does not by itself constitute an offence in the MOPOCA. Registration of cases, filing of charge sheet and taking cognizance by the competent court in relation to the offences alleged to have been committed by respondent in past is but one of the requirements for invocation of section 3. In this case, it is justified. Yes, there are cases. Continuation of unlawful activity is the second and equally important requirement ought to be satisfied. It ought to be, it is only if an organized crime is committed by the accused after promulgation of MOPOCA that he may see the light of the previous statute and cognizance taken by competent court. We say to have been committed an offence under section 3 of the Act. So in many cases of the accused, acquittal are there, charge sheet is not there, but investigation is stayed, and because of the very second, yes, correct.
Nothing.
Please.
For taking cognizance, there has to be 2 charge sheets, which is charged under section 3(1) or 3(2). If he is charged under section 2 to 5, there is no requirement of any charge sheet. That is the law. That law you will find in Lankesh's case.
Kavita. Yes.
So in order to file a charge sheet, in order to file a case in Mokoka, in Gutsita, if under 3(1) and 2, two charge sheets required, mandatory. Not to look into whether what is the ingredient, what is not there. If you want to file under 2 to 5, no charge sheet is required. He has to be abetting only that much should be seen. Now, as far as your three accused are concerned, the three accused which you are saying, Munaf and this,
Yes.
as far as I think, maybe they must have written section 312 also, but it should be under section 223, 225. So that is the difference.
But in this, as I was reading,
That I have already given one judgment here.
about what your honorable court is, I'll take that.
In one discharge application, I have already held this. So now, as far as this technical part, you can speak. Yes, look at it. So if you have anything other than that, yes.
The technical part, I would say it's a legal part in my report to submission. The Supreme Court, after this, I was going to read another Justice Paliwala judgment, Sandeep Om Prakash.
That is, Sandeep Om Prakash is referring to Shiva,
Shiva, right?
right?
But
Because
here it is stated what I'm submitting.
what is
My submissions are coming from there.
it?
Just 3 lines before we go to there.
Okay.
This, shall I just read it out?
Hmm.
Paragraph 11, Chillat is at 40 line. Section 3 would come into play only if respondents are proved to have committed an offense for gain or any pecuniary benefit or undue economic or other advantage. That the honorable court will take a note. Thereafter, please come to Sandeep Om Prakash, that is judgment number 4. My apologies, I have not marked.
Now, what would you call political gain? यहाँ तो वर्चस्व नहीं लड़ाई से. That is the only. What is the? You are not gaining any monetary benefit or something like that. That is not the case here.
Yes.
What is the case here?
That
Yes,
is
here is-
destroying my political image, which I
No,
am
no,
standing
no,
at.
not that. You people are political figures. Both of you. You people want to establish yourself as good politicians. Right? What is your gain and what is his loss? What is his gain is your loss. This is how it is going about. The which other judgment you want to read?
Kindly speak to the, sir, and my apologies are not marked.
Doesn't matter. You tell me which.
The fourth one. Kindly speak to judgment thereafter. The fourth one is Sandeep Om Prakash.
You want Superior judgment to be read or you want
Please, and it.
Yes.
So here, paragraph 22 to 24. The object is discussed. Now, the honorable court was of the view that for 3(2) it is not required. For other offences too, that sheet is mandatory. So that is what was
Lamkesh's case was not there. See, when Om Prakash came, I think, if I am not,
I have annexed it.
what is the date? Just have a look at it.
Yes.
This is 22 and the Lamkesh's case is
Just a minute. That is 21. 21/10/21.
January 22.
21 October 2021. That is Kavita Lankesh versus State of Kannada. This is 22 judgment. And this upholds.
Exactly. Now, yeah.
This is
So in this case, this was not argued there regarding
Yes.
this, which was already held, but this was never put to side. Lankesh's reasonings were not put to side because they were arguing only 3(1). 3(2) was not being argued because in this case, Om Prakash's case, there was already I think They have not referred the judgment at all. Anyway. Yes, because he was being tried under section 311, 1 and 2.
It appears that it is not referred.
It is not referred at all.
Not referred. However, it upholds Shivaji, which is not in issue.
I think both the judgments don't go contrary to. I have already
Yes.
held that in this court. That both the judgments are not contrary to, or no, there is no ambiguity between the judgments. Both judgments are dealing on different aspects. 3-1, the Shiva is dealing, Om Prakash Gupta is dealing with 3-1, whereas Lankesh's case is dealing with 3-2, 2-5.
And then comes Zakir Miraj. Then comes Zakir Miraj judgment by Justice Chandrachud.
So here I am on the Sandeep Om Prakash for the reason that the ingredients of organized crime, it is not continuing illegal activity.
I'm not saying that.
For organized crime to come into picture, this has to be there. Sir,
No, that
ultimately,
I have
we see-
taken that. You are saying that there should be 4 things that you are saying, that continuous unlawful activity, there should be some gain, there should be some loss. Activity should be continuous.
Please,
And
similar,
then member-
similar nature.
And
That also will take.
and should be a member of the syndicate, and all ingredients should be included. It should
Has
be
to
not
be
singularly.
I agree.
That I have
I
taken.
agree.
That I have taken.
Please. So to justify that, it is coming from this. That is why I wish to read 2-3 paragraphs. 22 to 24, the object is discussed. Wherein it is stated and sir,
Yes.
sir, before we go into that, the honorable court puts to us very that there is a political advantage to me. What it is not is mine.
This is
No,
just a,
it's a vice versa. But we will have to look at the fact on the FIR which has been registered. To invoke this, there has to be similar activities in past. So if we see that, then it justifies that it is not what is being alleged against me in the present FIR. Here it talks about object being a pecuniary benefit, undue economic advantage. So there is paragraph 23 which says that a place that in respect of a similar activity more than one time has to be paid. That the honorable court would find it in paragraph 23, 6A. Sir, why I say similar activities? Because I am referring more to judgment after this. Just cursorily look to show that similar activities were there in past and hence a case was registered and hence a bail was taken
after the promulgation,
after the total. Yes.
not before the promulgation. Before promulgation is only antecedent,
Understood.
nothing else.
So even if we take, you see the past, there has to be a similar nature of offenses.
Nothing else. After the promulgation, it has to be similar nature.
Please.
But before promulgation, antecedents only.
Sir, I'm taking a step more further. If take a look before, take a look after. You take as a whole and then you see whether it's this case worth invoking the chipper. Sir, just the last 2 paragraphs are very important.
Which one?
The same judgment, sir.
Shivaji.
Not Shivaji. Sandeep Om Prakash.
Sandeep Om. Paragraph.
I'll just show you. Paragraph 50, 50. It also discusses how their application of mine should be there, but since the charge sheet is not there, I'm not privy to what weighed with the authority. So I'm skipping that. Paragraph 50.
Vinappa versus Prakash.
Sir, in the middle, paragraph 50, it states
Paragraph 50 says following.
Now, what you
If
tell
organized crime was synonymous to continuous inactivity, two separate definitions were not necessary. That is exactly what he is saying. The definition themselves indicate the ingredients of use of violence in such activity with the object of
gaining pecuniary benefit are not included in the definition of considering the activity, but find a place only in the definition of organized crime.
exactly.
So if you want to take a lead, you have
So
to
now
see the past.
what does it say? Continuing
Yes. Correct.
Om Prakash.
Correct.
I think it was granted or
That
rejected?
is 51G, is very clear. Supreme Court 51G, if I recollect, the para 51G. That if he becomes a pious man after 1/12/2019, he is absolved from everything. But even a single activity after 1/12/2019,
Then he-
yes.
that is why they have put in.
Then IO should not wait for another activity, one single activity.
I'm only referring not with the facts and circumstances, but with what is held, what the law is laid down.
That's what I say.
That much submission. Even if it is
But
found,
yes, you see, I am not on that part. I am saying, how will you get out of the two offenses registered? You might say that it is registered with coercive, whatever, with bad intention, whatever it is, but it is there.
sir, it is an overall view which the honorable court would have to take in my respectful submission in order to see through how this FIR is registered and how the FIRs have been registered in
But
past.
right now, let the charge sheet be filed. How can I come to a conclusion right now? With the FIR only.
By FIR, sir, I've taken Munaf case, the last person. One acquitted, just two charge sheet.
No. We are talking about both. We are talking about only the two charges. They are, which you say are of the same offense. There are two charges, but thing is, the fact is, there are two charge sheets.
Existing.
That is enough for him to bring you into custody. Right now, you are saying these charge sheets are of the same offense, cannot be taken. That would only come in when the charge sheet comes.
Sir, now
At this stage,
I
that is what
understood. Mr. Makwana's case, what I've been arguing since now, that he has a political background. Others have not. So the advantage,
only for abatement, no?
abatement.
So that's what I'm
Abatement
saying.
in other
They
offenses.
don't even require an offense to be registered against.
Sir, but then we'll have to see that organized crime, the inclusion, and what are the ingredients? If I have this, Mr. Makwana, others have not. And what is the advantage or disadvantage to them in order to register a pecuniary benefit, continuing illegal activity of similar activities in past? That is what I was emphasizing. That similar activities has to be there in past. For invocation also. How similar activities, sir? I would throw some light on it in other two judgments. So that is only cursory reading. So it's not bother. So then the honorable court may have a judgment of trial. So this is that much near. After Shivaji,
This is High Court.
High Court judgment. Just a minute. The first, I'm sorry, the first Gohil lordships have it after this Pariwala judgment, Justice Pariwala judgment of the High Court of Justice Upaya in Bilkis Banu. So that would be after what we just read. Last page, 35, Visa report, High Court judgment.
Superior, yes, superior.
Sir, here the background was that the accused person, along with others, looted highways and had stolen articles, and this was a repeated thing in a similar activities, which this gang or a syndicate that way called in the act was doing. In that background, there were more than one charge sheet. There was an advantage. Now we see the ingredients are fulfilled or not. There is a continuing illegal activity, yes. There is an pecuniary benefit, yes. Economic benefit, yes. Similar activity, yes. And as a member or on behalf of the member, yes. Then it is justified to invoke, subject to what happens in trial. So here, please mark paragraph 6. There are majority of the case which says 379-114, just these two sections, 379-114, number 1, 3, and 4. And there are others which it notes but does not record. Sir, just what I have just told, one paragraph, 3 lines, paragraph 11, internal page 9 at the bottom. Merely because the applicant was not named in the FIR, factor may not influence the discretion. As noticed, there are at least 20 members involved. Complicity of the applicant can only be known after other members of syndicate are apprehended and investigation by police authority. Prima facie, the investigation reveals that applicant is a member of a syndicate as she used to deal with stolen articles which were looted by other accused from various highways of the state. The material records reveals the prima facie applicant along with other co-accused who are relatives and family members formed an organization syndicate in committing the offence, and hence the role as allegedly satisfied the criteria of the offence. It's a very similar, sir, I'm not reading. The similar thing is number 2 judgment. If there was a fracture gang, sir, number 2 it is after Shivaji. So the first judgment, the second judgment. There was a fracture gang which was operating and doing similar activities. Hence, an invocation was justified, though the Honorable Court had granted bail. Though it was after charge sheet. After charge sheet.
Name of the party.
Ahmad Mia Sayyid, which is number 2. Paragraph 6.1 to 6.3. I'm not reading, sir. Honorable Court may kindly just note it. That it was of invocation by justified because similar activity.
Paragraph.
Very well. 6.1, 6.2, 6.3. What was the nature of offences and how the organization was working, etc. Similar nature of offences. That is what is coming out from something from Pratali. Before I conclude, after Bilkis Banu, one page judgment is there of the High Court of Mohammed Ilyas, Mohammed Bilal Kapadia. 2 page judgment. What was the submission? Just 3 lines. A paragraph is unnumbered 3-1.
Mr. Rodriguez submits for numbering and provision.
Yes. There are 2 requirements to be satisfied. Number 1, that activity undertaken singly, jointly as a member of organized syndicate or on behalf of syndicate, very well. The second one is that in respect of such an activity, more than one charge sheet must have been filed in 15 last year. Yes. Sir, what does it mean in my respectful submission? that it has to be, what I'm emphasizing time and again, I'm sorry. But that is an important factor, that in respect of such an activity means it's a similar activity in past. As what I take the honorable court to Bilkis Bano and Ahmed Mir. Same.
Past, what do you mean by past?
Said,
Which past?
loot,
After promulgation, or before promulgation?
after promoting. That makes my case on a better footing, sir, if we see that way. And the Honorable Supreme Court has granted bail. The rest, Kavita, Lankit and everything is annexed, and therefore the Honorable Court is already aware about it. I'm not troubling the Honorable Court. That is
I'll
all,
put everything, I'll put all your submissions.
please, sir. I'm grateful for patient hearing. Deeply obliged.
आप क्या कर सकते
On Monday,
Sir,
हो? 3 तारीख है
sir, can it be on
कौन तारीख
16th, first,
Can it be on Friday, sir?
फ्राइडे
17th again.
10.
10 it is, no, I am not, 10th and 17th I am. 16th,
This would otherwise. One more. I would request the shortest possible date, subject to convenience.
when are you convenient
13th was convenient, but it is not convenient, so 16th is the first available date.
16 week
Sir, one more submission I need to make on this particular case, sir. So coincidentally, sir, I am advocate of the co-accused and there are some allegations leveled against one of.
which co-accused number name
Sir, not in this particular case, but the person my learned friend is referring to and the case in which he got convicted to and the Honorable High Court has released. So, sir, I am not.
Mr. Solanki,
the other side
Yes, sir.
you took up
he cannot be permitted to.
I'm not, sir, I'm not making any.
Sorry.
If I can just.
see I have a competent
Sir, what I am trying
He
to.
cannot have any.
listen to me I have a competent special PP here
No, no, sir.
if you don't have trust in him then you tell me
No, no,
He
sir.
is not even a complainant.
At least let me complete my submission. I'm not even arguing. I'm requesting this honorable court to, I may be maybe allowed to grant.
sir and he is
Sir.
competent enough
Sir, sir.
that means you doubt him when you doubt him
No,
I
no,
will
no,
agree.
sir. There is no doubt on him, sir. He is my
I don't
senior.
doubt it.
And I totally trust him, sir, but I got some instructions that we might be filing, sir, objections for the original complaint, and that is the reason I was mentioning before this
Anything you
court.
won't be able to file, you will have to file it through the,
Sir, I will do that. Yes, sir.
so either way, he is going to do everything.
Sir, leave it to me. Sure.
Vedanta, he did after that.
Okay.
Thank you. Deeply obliged.
Sir.
ચલો report નું કેવું કરવું? આવી ગયું છે. અને એમની એક પ્રેયર મોડિફિકેશન છે કે અમારી જ્યાં સુધી થાય ને ત્યાં સુધી અમને અમદાવાદ ફિલ્ડમાં સારવાર છે. I am not objecting to that modification of prayer. So this can be disposed of accordingly. એમને એક એપ્લિકેશન આપી છે અરજદાર જ્યાં સુધી સંપૂર્ણ સારવાર પૂર્ણ ન થાય.
That I will put it in the order.
It is there, and
This
now there is a report.
temporary bail application is rejected.
They-
However, it
Alternate
means
prayer.
that whatever prayers alternate are taken, that should be.
No, but there are 3 alternate prayers. One is for special room. I have taken
Subject to five
instruction.
grand.
No,
Hello.
no,
Or
no,
subject to payment of the money.
no, there is one more. I have talked to the RM because there were directions from this honorable court. RMO says that as and when required, we can put him to the special room. As of now,
પૈસા આપશે. Why do you want to?
but સરકારમાં પૈસા ન લઈ શકે ને.
પહેલા પૈસા આપશો ને sir. Subject to depositing in advance.
What RMO told me is that this is a government hospital. Special room are occupied by the patients who require some special treatment.
Special order की आपके by the order of the court.
Please.
However,
Then I leave it to honorable court, but
However,
this is what my instructions were.
however, the accused shall deposit the money in advance.
Sir, then
If the jail authorities can put him in a
Please.
ward only,
yes,
but if he wants that, then he has to remunerate the civil hospital.
Please. So my third prayer is that only, sir, the report says that we are not allowed to even, private doctors should enter the hospital.
that they are not allowed.
So my second prayer is that only.
But that they are not allowing reason is that because if something wrong happens, that is what their apprehension was, then who is to be blamed? Hey, somebody said that you invited,
I will take care by the.
this is the apex hospital of the state. They do not require any other, they have all super specialists. So far as that is concerned, there were two contentions which.
Who is the doctor? Your doctor.
So I have just mentioned that
Government hospital, Doctor Ponchi.
RMO is,
Who is, no, not RM. Who is taking, who is the specialized person?
a team of doctors is taking.
So because
They can.
neurology plus
Team of
psychiatry
doctors.
is a ત્રણ-ચાર expert doctors
I
are
will
help
not put the
treatment.
name, but I will refer to it, the team of doctors means however, in, by phone or by video conferencing, referred, discuss with the doctor mentioned by you.
I'm obliged to
Sir, kindly appreciate, that will be an issue between the doctors. Kindly appreciate, proof it. If they are of the same level super specialist doctor, why should they consult anyone else? Kindly, because, kindly see the report for a moment, then I will talk. Kindly see the report. Ahmedabad, Saga, I am ready, I am consenting to these prayers 1 and 2. So far as special room is also honorable court, because I had a word with RMO as per the order of this honorable court.
જેલવાળા ના આપે.
ના એવું નથી, જેલવાળાને પણ આપે, પણ અત્યારે એની સ્થિતિ સારી છે કે સ્પેશિયલ રૂમ ની જરૂર નથી. સ્પેશિયલ રૂમ આર ઓક્યુપાઈડ બાય સમબડી એલ્સ હુ રિક્વાયર સ્પેશિયલ. અત્યારે એમની કોઈ સારવાર એની સુધારો છે એમની સ્થિતિમાં. ફ્રોમ ધ ડે વેન હી વોઝ બ્રોટ ઇટ હેઝ બીન ઇમ્પ્રુવિંગ. ધેટ ઇઝ વોટ ધ રિપોર્ટ સેઝ.
Sir, report में હું કહે છે કે સર there is more.
સર આપશું જે બી આપવા યોગ્ય હશે
સર અમે
આપશું.
મારી એપ્લિકેશન છે તમે સ્વ ખર્ચ લખ્યું that may be granted sir. I'm obliged to. My request, number 1 and 2, may I be permitted to appear online? I have been held up in a matter.
Now you don't require. You want to join us
Just to hear, mark my presence, sir.
You do one thing. ID password will be given to you just now.
Please, sir.
You can log in as in on back there.
Mr. Desai's office is also held up somewhere. I spoke to him. I'm grateful.
Log in whenever the matter is.
Please, definitely. I'm grateful.
Okay, see, BL Sahib,
Sir, number. So, few of the one was order my.
Order.
So, today or
Today.
sir. Obliged on.
BL Sahib, PM Gopal.
અને એના કાલે એમનું જેલ ટ્રાન્સફરનું છે. મે બી કેપ ટુમોરો. IU was on leave for till 5th. From 6, 7, 8 he is in high court. પેલા બે લોકો જે સરેન્ડર ન થયા એમને વિટનેસ તરીકે છે પેલા મોરબી CCTOC માં.
રાજકોટ અથવા મોરબી જેલમાં આપણે જેલર સાહેબ નો રિપોર્ટ મંગાવ્યો આવી
ધર્મ મને કઈ નથી.
આપણે જેલ અમદાવાદ અને બરોડા જેલમાં આપણે પેપર
અમે તો practice કરી છે.
આપણે બે લાવી છે
આવી ગઈ છે શું લખ્યું છે એમને?
એમાં એવું લખ્યું છે કે આ જે એવી બરોડા જેલ છે અને બીજા જે અમદાવાદ જેલ છે ને એનો અભિપ્રાય એવો છે કે લેતી ગઈ અમદાવાદ જાય છે રાજકોટ બેઠો
રાજકોટમાં છો ને તમે? ના
અમદાવાદ બરોડા
એક બરોડા છે. બરોડા એ રિપોર્ટની કોપી આપી મેલ આવ્યો છે મંગાવ્યો.
અને IU નો રિપોર્ટ કાલે આવી જશે.
આવતીકાલે
ચલો નેક્સ્ટ. ઇલેક્ટ્રિસિટી વાળા કોણ બોલાઈ લે ને ફટાફટ.
એ ડી મુકાઈ દઉં છે. આવતી મુદતે ડી મુકાઈ દઉં. આજે ફર્સ્ટ ડેટ છે
ના ભાઈ તો પ્રાઇવેટ છે એ ના આવી શકે.
નહીં મગદાણીભાઈ આવે છે.
ગવર્મેન્ટ એપોઇન્ટ કર્યા.
નહીં મગદાણીભાઈ તૈયાર કરીને લાવે છે ને રૂમ એવું.
હા
એટલે એટલું હું એવું બોલું
appearance એમનું નહીં આવે.
નહીં એપિરન્સ તો હું જ આપું છું.
હા,
એપિરન્સ તો હું જ આપું છું.
appearance આપનું આવશે, witness બી આપ call.
હા હું જ કરું.
Gyanibhai has only to deal with those cases which are.
અમે જો ફાઇલ પોલીસ સ્ટેશન થી મંગાવીએ ને એના બદલે CED માંથી મંગાવીએ એના માટે અમે એમને કહી છે.
સમજી ગયા ને? આપણે DV આપે જ રજૂ કરો.
હા આપ મેરેજ કરો બરાબર. જે અમે ફાઇલ જે મંગાવીએ છીએ ને એમના માંથી મંગાવી દઈએ છીએ.
Witness બોલાવવાનું ચાલુ કરો.
10 નંબરમાં સાહેબ 10/2023 માં ફરિયાદ છે.
આવી બોલાવી લીધી.
ભક્તિસિંહ જે બી પરમારભાઈ જેવી પરમારભાઈ,
JV Parmarbai.
ભગતસિંહ કેપી વાલવા,
Well.